Hey friends, hi. Welcome you all to Navkar Digital Institute. And today we are going to discuss the revision test paper which is recently being issued by our mother institute ACCA, which is applicable for May 2021 examination. Friends, normally till now, whenever a revision test paper was being issued by ACCA, it was having two things. One was the amendments which were applicable in that particular attempt. And second thing which was covered in that is those set of questions which help a student to make a mindset that how he should prepare, how he should test his aptitude and knowledge, and which type of questions may be expected or which type of questions probability is there of being them asked in the upcoming attempt of May 2021. So what I mean to say is that every time the RTP covered two things, the amendments and the questions. But this time the RTP is having only the set of questions. Means it is not covering any of the amendments which are applicable for November 21 examination. Then is it so that there are no amendments? Then the answer is no. It is not so that there are no amendments. There are amendments. Right, and how the amendments are being discussed, then if you see, if in May 2021, if there is an examination, right, then November, December, January, February, March, April. These are the last 6 months preceding your attempt. Amendments not applicable in your May 2021 examination. So all the amendments which are being introduced by way of budget, right, are not applicable to May 2021 exam students. They will be applicable from November 2021 exam onwards. And all the amendments till 30th October 2020 are applicable in May 2021 examination and are covered in latest edition of module. So if you are referring to the latest edition of module, then it is covering all the amendments. It is amended for May 2021. So there is no separate material or there is no separate list of amendments which generally we found in RTP. So this is when we refer to the latest module, it is absolutely an amended one. So in this RTP, we are going to discuss only those set of questions which the institute has asked. This is also being clarified here very clearly. For May 2021 attempt, for the paper 4, that is corporate and economic law, relevant material is of November 20 edition containing relevant amendments made latest by 31st October. Besides this, refer the booklet on MCQ and case scenario of Jan 21 edition containing independent MCQs and also case scenario based MCQs. So first read the study material thoroughly and then read this particular MCQ. This will provide a thorough base to you that how you should prepare and approach for the upcoming examination of May 2021. That is how the things are going to work out. Now, friends, so let me again give a disclaimer that this amendments we are going to discuss from May 2021 perspective. So there are certain answers, certain questions, the answer to which may change if we go for November 2021, because at that point of time we may apply the amendments which are brought by budget, but at today's time we are not going to apply any amendment which was brought by the budget. So with this brief discussion, let us start the discussion with respect to the first we will move towards the MCQs. In that MCQs also we will first move towards the case study scenario based MCQs. First, if we focus, then normally we have a trend that first we always read the case, then we read the questions, and then we go for analysis of same. Now before you do the analysis, you need to reread the case. So what kind of strategy we should generally follow is that first read the questions. So at the back of mind, you can always have a trap that when you read a case, in which perspective of case or in which point of case you need to highlight or you need to focus a lot. So if we go for first the questions, state in light of the given facts whether the 5 members blah 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 were eligible for filing class action or end under section 244. So class action is 245 or 244, means we need to check up that whether the requisite number of members are there who are eligible to file an action under operation or mismanagement if found in company. So when we need to look out from that perspective. Whether the decision of tribunal can be considered as valid with respect to termination of agreement made between company with Mr. Dev as well as setting aside the contract of transfer of property respectively. So as a consequence of operation and mismanagement, tribunal may take certain actions. So we need to keep a watch on whether the actions are valid or not. Okay. Prior approval of which authority would have been sufficient for Mr. Vaibhav for examining Mr. Daya on oath? So कोई इंसान है जिसको examine on oath करना है, किसकी approval चाहिए? Right. And how much maximum amount of fine could be levied on Mr. Daya for refusing to sign the document containing the notes taken by Mr. Vaibhav? So we need to think on the penalty aspect also. Okay. Mr. Ramanuj was having an authority to exercise the power to make an order of arrest of Mr. Arjun on the basis of notes of examination received from Mr. Vaibhav, and to which authority Mr. Ramanuj would have forwarded the copy of arrest order along with the document containing notes. So while reading the case, we need to also focus on the powers of investigation officer to arrest a person. What was the last date available to tribunal to give response to an application made by company with respect to its employee as well as company to file an appeal with appellate tribunal? So it is basically talking with respect to section 280, which provides protection to employees in case of operation and mismanagement, or in case of investigation, inspection, inquiry, investigation going on. So basically seeing these questions, one can understand that the whole case study revolves around 2 aspects. One is inspection, inquiry, investigation, and another is operation and mismanagement. Around these topics, the whole of the case study is revolving or is involved with. Now let us have a look at the very first case scenario for the revision test paper for May 2021. B Limited, Balfour Limited is an unlisted company having total 70 members with a paid up capital of rupees 42 lakh, having a turnover of 200 crores as per the audited financial statement for the year ended 31st March 2020. So as at the back of the mind, there is a point with respect to who are applicable for. So for that, total number of members are important. 5 members holding in total 4% stake in a company met in person to discuss about the operation and mismanagement going on in Balfour Limited and to do something about it. One of the members, Mr. Ravi, suggested that we 5 members should file a class action application to NCLT to get a resolution in the matter, to which another member, Mr. J, told that he is in contact with 3 other members of company holding in total 3% stake, for also finding the activities going on in the company to be unjust. So 5 plus 3 other members, totaling 8, will be able to file an application to tribunal under section 244. So 5 members थे और 5 में से एक किसी और 3 को जानता था जो भी उनको ज्वाइन करना चाहते थे. Okay, so this is of use. The application of complaint for operation and mismanagement was filed to tribunal on 4th of June with the consent of 8 members. The said application provided the details of agreement made by Balfour with Mr. Dev, a relative of director of Balfour Limited, Mr. Raj, with suspect to continuous supply of raw materials to Balfour, for which Raj received a commission from Mr. Dev in cash for offering a contract to him. Also, another director, Mr. Jayesh, had improperly transferred a property of the Balfour Limited on 6th of March to Mr. Prakash. So June, April, May, June. Okay. So we need to see that time limit of 3 months also here. The tribunal, on receipt of such application, made an order directing investigation into the affairs of the company. Also, the agreement made between Mr. Dev was ordered to be terminated after giving notice to Mr. Dev and obtaining his consent. However, no compensation was ordered to be paid to Mr. Dev for cancelling of agreement. The contract with respect to property transferred by Mr. Jayesh was also ordered to be set aside, as it would have been deemed to be fraudulent preference. In such case, transaction would be made by an individual in his insolvency. ओके, सो ट्रिब्यूनल ने 2 काम किए. एक तो जो रिलेटिव था, डायरेक्टर का रिलेटिव था, उसके साथ जो कॉन्ट्रैक्ट किया था वो कैंसिल कर दिया, एंड दूसरा ये जो प्रॉपर्टी ट्रांसफर की थी वो भी वॉइड डिक्लेयर कर दी. And NCLT ordered to government. Simultaneously, the central government ordered for the investigation into the affairs of company on receipt of order from the tribunal, and the task of such investigation was assigned to SIFAO. So NCLT told to government, and government assigned this matter to SIFAO. The director SIFAO, on getting such order from central government, designated 3 inspectors of investigation, and soon the investigation started. One of the investigating officer, Mr. Weber, issued summons to 2 employees of Balfour Limited, Karan and Arjun, as well as Daya, an employee of Kafur Limited, an associate company of Balfour, after taking required approval. So here 219 also comes into picture, where you, along with investigation of a company, you start an investigation into some persons who are connected with the company, that is employees and an associate company. The aforesaid persons attended at the place at which they were summoned by Mr. Weber and were examined on oath one after the another. यानी ये सबकी पूछताछ हुई. During the said examination, Mr. Weber took down the notes in writing, and he read over the notes taken by him to all the persons examined, and after the end of examination. After hearing the said notes, Mr. Karan and Arjun signed the documents on which such notes were written, but Mr. Daya refused to sign such document without any reasonable cause for the same. On the same day, but then he thought that there would be no issue in signing, and so he signed the same after 20 days. So 3 लोगों का एग्जामिनेशन हुआ था, 3 में से 2 ने साइन कर दिया, पर एक दया वो साइन नहीं किया. उसने तब साइन नहीं किया, पर उसने 20 दिन के बाद साइन किया. Mr. Weber forwarded the notes taken by him to the assistant director of CFAO, Mr. Ramanuj. And on the basis of such notes, he derived that Mr. Arjun has committed an offence under Section 447 of Companies Act, which Mr. Ramanuj confirmed with Mr. Weber via email. So then, a case of fraud was also being confirmed. Mr. Ramanuj accordingly passed an order for arrest of Mr. Arjun. After recording in writing the reasons for such arrest, he immediately forwarded the copy of order to the concerned authority, along with the document containing the notes taken by Mr. Weber at the time of examination of Mr. Arjun, which indicated that he has committed an offence under Section 447, that is with respect to fraud. Company, on coming to know of such arrest of Mr. Arjun, wanted to give termination to him and also wanted to demote Mr. Karan to position of junior assistant from the position of senior assistant during the pendency of investigation. And for that purpose, it made an application to tribunal for the same on 10th of October. Here, Section 218 is attracted, which gives protection to employees. In response to the said application from company, the tribunal passed an order on 26th of October allowing termination to be given by Mr. Arjun, but it objected on the decision of company for reduction in the rank of Mr. Karan from his current position, against which company filed an application with the appellate tribunal on 15th November 2020. This is the scenario with respect to which you can say the whole case revolves, or the whole case goes around. Now moving to the very first MCQ for the evening. Here we go. State in the light of given facts whether the 5 members holding in total 4% stake in BALF company or 8 members holding 7% stake in company were eligible for filing application for class action and under Section 244 respectively of the Companies Act 2013. Let's have a look at this. Here we need to focus on 2 things. One is, let us see with respect to class actions under Section 245. There can be 2 scenarios: company with share capital, company without share capital. Here the company is with share capital. So company with share capital. So we need, how many people are eligible? So in order to widen the scope, lowest of, like you take 100 members. या फिर just go for 5% of total number of members, or if the company is unlisted company, then members whose shareholding is minimum 5% of issued share capital. And if the company is listed company, members whose shareholding is minimum 2% of issued share capital. These are the people who are eligible for class action. Now friends, if you see here, the question of 100 members does not arise. Reason, in total there are 70 members. Now, if we do 5% of 70, it comes to 3.5. So it comes to round about 4 members. So 4 members are eligible to go. Right. And here the application was being made by 5 members, right? So it's obviously yes. Then when it comes to application under section 244, application under section 244, right? Then you can say that again the company with share capital, then lower of A 100 members, then B 1/10 of members, yani 10% members, or C a member or members whose shareholding is minimum 10% of issued share capital. So again, this question of 100 members does not arise. What is 1/10 of total members? So it comes to 7 members. So 7 members can make an application. So if there are 8 members, then they are eligible, obviously. So you can say that yes, if 5 members or 8 members were eligible for class action, right? Then for class action, 5 members are absolutely eligible because we need minimum 4. And for action under section 244, we need minimum 7 members. And here we are having 8 members, right? So which are the options available? For filing application for class action, 5 members were eligible. Okay. And also for filing application under 244, 8 members were eligible. This is correct. For filing, because here we need minimum 4, here we need minimum 7. For filing application for class action, 5 members were ineligible. गलत. तो ये ऑप्शन ही चला गया. ये है. For filing application for class action, 5 members were eligible. But for filing application under 244, 8 members were ineligible. ये गलत है. तो ये चला गया. For filing application for class action, 5 members were ineligible. गलत. ये भी गलत. So B, C and D are wrong. So the correct answer is what? The correct answer is 8. Right? The correct answer will become what? A. This is the first case. Now, second point, whether the decision of tribunal can be considered as valid with respect to termination of agreement made by Balfour with Dev, was a relative of director, as well as setting aside the contract of transfer of property which was made by another director. The decision of tribunal, the very first option, the decision of tribunal for termination of agreement made by Balfour with Dev was considered valid. Okay. Also, the decision of setting aside the contract of transfer of property can be considered as valid, as such transfer was made within 6 months before the date of making of application to tribunal. Here it is not 6 months. Here it is 3 months. So this is wrong. So can I say this option is gone? The decision of cannot be considered as valid as no compensation was ordered to be paid to Mr. Dev. This is wrong, because no compensation is required. Also, the decision cannot be considered as valid as was not made within 90 days before the date of making application. This is also wrong. The decision of tribunal for termination of agreement made by company with Mr. Dev can be considered as valid. Perfect. Also, the decision of cancelling the contract of transfer of property can be considered as valid, as such transfer was made within 3 months before the date of making application to tribunal. This is correct. The decision of tribunal for termination of agreement made by company with Dev cannot be considered as valid, as no compensation was ordered to be paid to Mr. Dev. This is wrong. However, the decision of setting aside the contract can be considered as valid, as such transfer was made within 3 months. So that is valid. But whole option, ऐसा कौन सा option था जो पूरा valid था? Then it was option C. So डायरेक्टर या डायरेक्टर के रिलेटिव के साथ कोई भी अग्रीमेंट किया हो वो एब्सोल्युटली टर्मिनेट कर सकते हैं. उसके साथ साथ अगर कोई प्रॉपर्टी का ट्रांजैक्शन हुआ तो उसे भी, अगर हम पिछले 3 महीने में हुआ तो उसे भी हम इनवैलिड डिक्लेयर कर सकते हैं. इफ had it been an insolvency of an individual, it would have been considered as an fraudulent preference. Next, prior approval of which authority would have been sufficient for Mr. Weber for examining Mr. Daya on oath? So it is Director Sifau. And how much maximum amount of fine could be levied on Mr. Daya for refusing to sign the document containing the notes taken by Mr. Weber? So here, section 217 comes into picture. And in 217, we have specific requirement that if a person is examined on oath, the notes are taken. Then the notes are read. And once the notes are read, then the notes are to be signed by a particular person. But if a particular person, not 6, 8, if a particular person without reasonable cause fails to, or refuses to give any document, to produce any document, or to furnish any information, or to appear personally, or to sign notes of examination. If any such thing happens, then in that situation, the penalty is imprisonment up to 6 months, and fine minimum 20,000, 5,000, maximum 1 lakh, and it is offense of continuing nature, rupees 2,000 per day. Offense continues. This is the provision which is applicable in this particular case. So what will be the amount of penalty? The default was continued for 20 days. 1 lakh plus 20 days into 2,000 per day. तो मिस्टर दया के ऊपर मैक्सिमम कितने पेनल्टी रख सकती है? 1,40,000. सो प्रायर अप्रूवल इज नीडेड ऑफ डायरेक्टर सिफाव एंड पेनल्टी कितनी लग सकती है? 1,20,000. सो लेट अस स्टार्ट एग्जामिनिंग ऑल द ऑप्शंस व्हिच आर देयर. Prior approval of Director Sifau would have been sufficient for Mr. Weber, correct? And maximum amount of fine that could be levied on Mr. is okay. This is wrong. So this option is wrong. Prior approval of central government would be sufficient, wrong. And maximum amount 40,000, that is also wrong. Prior approval of Director Sifau would have been sufficient and maximum amount of fine that could be levied is 1,40,000. This is correct. Prior approval of CG, this is wrong. And no fine that could be levied on Mr. Daya as he signed the said document within 30 days of being examined. This is also wrong. There is no such provision. So if you see, absolutely perfect is point number C. Is which point? Point number C. Next, Mr. Ramanuj was assistant director, having the authority to exercise the power to make an arrest order on the basis of notes received from Mr. Weber, and to which authority Mr. Ramanuj would have forwarded a copy of arrest order along with the document containing the notes. Right. So absolutely, first of all, is the action taken by Mr. Ramanuj correct? The answer is absolutely yes. And he would have forwarded the documents to whom? To Director Sifau or to Sifau. So first they say no, as such notes. Okay, no to galat hi hai. Because the answer is absolutely correct. Yes, as such notes constitute valid evidence to be used against Mr. Arjun. And Mr. Ramanuj would have forwarded a copy of arrest order along with document containing to central government. Okay, this is wrong. No, then this is wrong. Yes, as such notes constitute, एक ही option बचता है, as such notes constitute valid evidence to be used against Mr. Arjun, correct? And Mr. Ramanuj would have forwarded the copy of arrest order. No is also wrong, and NCLT is also wrong. The document to Director Sifau or to Sifau, that is absolutely correct. right? So that is with respect to section 212. That is with respect to arrest order. What was the last date available to tribunal to give the response to application made by Balfour Company? Now this is section 218. Application by company, and वहां से how many days? 30 days. Right, and order of NCLT वहां से अपील करनी है तो कितने दिन? 30 days. Now let us see कि भाई किस दिन एप्लीकेशन की थी. तो if I see the RTP which is of institute, Balfour application on 10th of October. वहां से 30 days, तो 9th of November 2020. उतने दिन में ट्रिब्यूनल को अपना आंसर दे देना होगा, जबकि ट्रिब्यूनल ने आंसर दिया कब? 26th of October. इन 26th of October 2020 को अगर आंसर आता है तो आप उसके 30 डेज में अपील कर सकते हैं, यानी 25th of November 2020. और हमने अपील कब की थी? 15th of November. So based on the last date available, which is the last date to file, so it's 9th November and 25th November. These are the two dates. The first option is 10th November, it is wrong. 26th November also wrong. 9th November correct, 25th November correct. 10th November wrong, 25th December wrong. 9th November correct, 26th November wrong. So correct is 9th November and 25th November. That is, जिस दिन एप्लीकेशन करो उसके 30 डेज में ऑर्डर आएगा, और जिस दिन एप्लीकेशन करते हो ऑर्डर आता है उसके 30 डेज में यू कैन ऑलवेज प्रिफर एन अपील फर्दर टू whom, that is you can say to NCLA. So this is the very first, you can say, case study based scenario which we particularly saw with respect to the case. Now the second case study. Before you move to case study, as usual or normal practices, we first look at the questions, then we do case study. Shri Hari Textile Limited and its official failed to submit any reply to the return notice issued by ROC within the time specified in notice. How much fine can be imposed for such failure? So focus is in case of inspection inquiry. If any document is demanded and if you fail, what will the panel? So prima facie we need to focus on section 206. From the case scenario, it was observed that the registrar seized certain documents in the course of inquiry. After inspection, which procedure is to be followed pertaining to those documents? So basically something is with respect to section 209, which talks with respect to entry, search and seizure. What is the requisite requirement for increasing the remuneration of directors, including whole-time directors and MD, to 12%, maximum is 11%, so that it is in accordance with the relevant provisions. So basically we are talking with respect to section 197, read with schedule 5. So we need to focus on that too. The case scenario states that ROC had called ex-directors of company for examining them during the inquiry. Is the registrar empowered to call ex-directors? So again, it's focused on section 206. According to case scenario, while inspecting the company, the team of CIFAO came to know that income tax authority has already initiated investigation against the company. From the given option, choose the correct one. So it is something with respect to section 212, where investigation is being carried on by CIFAO, and at that point of time, no other investigation can continue. So these are the key focus points. Without even studying the case, we came to know that this might be targeted, and this have to be targeted. So when we're studying the case, we will pinpoint and focus when this relevant points or factors comes into picture. Let's have a look at a case. Shri Hari Textiles Limited was incorporated in year 2010. Its register office is situated in Connaught Place, New Delhi. It has filed its audited financial statements for financial year 1920 well within time with the jurisdictional ROC. The ROC inspected the statements and after reviewing them, felt the need to seek clarifications on certain matters. Inspection is going on, inquiry was done. Accordingly, a return notice was sent to ROC by the ROC to the company and its officials, directing them to comply with the notice within 30 days of its receipt. However, the company and its officials failed to reply within the time specified in notice. So, company and उसके officers ने सही समय पे reply नहीं दिया. बेशक यहाँ पे फाइन बनेगा. The ROC initiated the inquiry and proceeded further for inspecting all the documents of company. While conducting the inquiry, the ROC on prudent, genuine grounds believed that some of the documents and other vital information in relation to company would be destroyed or altered by the officers in the company. With a view to safeguard the documents, the ROC obtained an order from the special court and thereafter seized all such material. So ROC ने सर्च एंड सीजर किया खास करके डॉक्यूमेंट्स का. उन्हें रीजनेबल ग्राउंड्स लग रहे थे एंड बेशक उन्होंने स्पेशल कोर्ट की अप्रूवल ले ली थी. सो एवरीथिंग इज गोइंग वेरी मच परफेक्ट under section 209. While inspecting some of the documents, the ROC came to know that Board of Directors has passed a board resolution and thereby increased the remuneration payable to directors up to 12%, which was a sharp increase of 5% from the preceding financial year. Prior to the inquiry, two directors of company, namely Mr. X and Mr. D, got retired. The registrar found from the inspection of documents that they were involved in certain dealings, which included selling of assets of company. On basis of such information gathered from inspected documents, the ROC sought some clarifications from both of them regarding the dubious, that is the doubtful transactions. However, Mr. X and D refused to appear before him, showing their non-availability in the town, and also represented to a common representative that they were no more a part of Board of Directors of Shri Hari Limited. So they denied to be the part of the hearing. But yes, being ex-directors, being the inquiry going on with respect to the period during which they were in position, they need to come. After the completion of inspection and inquiry, the registrar submitted a written report to government in respect of the finding against the company. The reports mentioned that there were major discrepancies in the assets and liabilities, as well as profit and loss statement filed by the company. On receipt of report from registrar, the central government considered it necessary to investigate the affairs of company by CIFAO, and accordingly, by an order, CIFAO was directed to conduct the investigation of Shri Hari Textiles Limited and submit his report within the stipulated time. So गवर्नमेंट ने बहुत सारे फ्रॉड्स देखने के मामले में गवर्नमेंट ने डिसाइड किया कि वो सिफाओ की इन्वेस्टिगेशन बिठा देंगे. As instructed by the government, CIFAO authorized some of its inspectors to investigate the affairs of the company. The team deputed by CIFAO included experts in the field of cost accounting, financial accounting, taxation law, and forensic auditing. While inspecting the company, the team CFO came to know that the income tax authorities has already initiated the investigation against Sri Hari Limited. So whether they can continue alone or both will do investigation, we will see to it. So again, whole of the case study mainly revolves around inspection, inquiry and investigation, ranging from section 206 to 229, and along with that they have added a pinch of an element of managerial remuneration. Everything else is one and the same. First section 206 comes into picture. Which says that company and of every officer for fine up to rupees 1 lakh and additional fine of rupees 500 per day offence continues in case of continuing offence. So हमारे एग्जाम्पल में कंपनी ने उनके ऑफिशियल ने डॉक्यूमेंट्स नहीं दिए थे तो क्या पेनल्टी लगनी चाहिए? तो वेरी फर्स्ट, फाइन अप टू रुपीज 1 lakh, additional fine of 500. Okay, this is correct. 1,50,000 wrong, 1,000 is also wrong, so wrong. 1 lakh correct, 5,000 is wrong, 2 lakh wrong, 5,000 is also wrong. So first option is absolutely correct, and this is as per section 206. Subsection 7. It was observed that ROC seized certain documents. After inspection, what should be done? Give back that documents back to the company. The ROC is required to submit such documents in special court. Wrong. The ROC is required to forward all such documents along with report to government. Wrong. The registrar is required to return such documents back to company after making, if necessary, the copies of them. Right. The registrar is required to retain such document until further instructions is from special court. Wrong. So best is to give back the copies, and if needed, you make the copies of them. What is the requisite requirement for increasing the total remuneration? Okay. Board resolution is correct. Needs to be authorized at the general meeting. Correct. And thereafter duly sanctioned by ROC. This is wrong. No ROC approval is required. Board resolution correct. Authorized by general meeting correct. Thereafter duly sanctioned by tribunal. This is wrong. No tribunal approval is required. Board resolution perfect. Authorized by company in general meeting subject to schedule 5. Okay, this is perfect. Board resolution is perfect. General meeting is perfect. Thereafter duly sanctioned by central government to regional director. This is wrong. So ultimately board resolution is needed and an ordinary resolution in the general meeting is needed subject to compliance of schedule 5 when you want to increase the remuneration and the total remuneration goes beyond 11% because 11% is the ceiling limit. The case scenario states that the ROC had called ex-directors of company for examining. Is the ROC empowered to? Yes, absolutely empowered. खुद के पास power है. Cannot wrong. सेंट्रल गवर्नमेंट की अप्रूवल चाहिए, ट्रिब्यूनल की अप्रूवल चाहिए. सो यस, आरओसी इज ऑब्वियसली एम्पावर्ड. खाली एक रिटर्न नोटिस भेज के उनके पास से इंफॉर्मेशन मांग सकते हैं, उनको पेश होने के लिए भी बोल सकते हैं. According to case scenario, while inspecting the company, the team CFO came to know that income tax authorities already initiated the investigation against the company. क्या कर सकते हैं? तो to tell them and their investigation will be stopped. CFO has to put its investigation on hold. Wrong. CFO will proceed with its investigation on the basis of report submitted by income tax authority. Wrong. CFO will proceed with its investigation while income tax authority shall keep on hold its investigation. Correct. CFO simultaneously will no. So हमारा इन्वेस्टिगेशन जब तक चलेगा तब तक उनका इन्वेस्टिगेशन शुरू. That is for sure. ये यहां पे केस स्टडी बेस्ड एमसीक्यूज खत्म होते हैं. Now we move towards independent MCQs. The very first is based on securitization and asset reconstruction of financial assets and enforcement of Security Interest Act 2002, and from options it needs that it's basically based on section 3, subsection 3, which talks with respect to the eligibility criteria. ABC Limited incorporated in India wanted to register as an ARC to commence the business of asset reconstruction. The company made all the arrangements required for realization of the financial assets and shall be able to pay the periodical returns on respective due dates on the investment made in the company. Good. The directors are well qualified and had nearly 25 years of experience in the field of finance, 10 years of experience in reconstruction and securitization of assets. Very good. The company has also complied with all the requirements of regulations and guidelines issued by RBI. Very good. The details of profits made is 16-17 200 crores loss, 17-18 500 crores profit, 18-19 700 crores profit. एक क्राइटेरिया है सेक्शन 3 सबसेक्शन 3 का कि आप जब रजिस्ट्रेशन के लिए अप्लाई करते हो तो उसके पिछले 3 सालों में कभी भी लॉस नहीं होना चाहिए. देन द एआरसी कैन बी रजिस्टर्ड. गलत. द एआरसी कैन बी रजिस्टर्ड. गलत. द एआरसी रजिस्ट्रेशन कैन नॉट बी मेड. यस, since there is loss. RBI has no power to, wrong. So means the ARC registration cannot be made since they have lost in one of the preceding financial year, which is absolutely proceedings under Prevention of Money Laundering Act was started against Mr. Suraj. Through an order, property of Mr. Suraj was attached. Mr. Suraj preferred an appeal to appellate tribunal. Mr. Suraj is adjudicated as insolvent during the pendency of appeal. What will happen? Will the appeal stop? No. But the official assignee or the official receiver who will be appointed by the court, who has adjudged him as insolvent, will continue. Proceedings will stop. Galat. His legal representatives will continue proceedings. Death thodi hui. The official assignee or official receiver, as the case may be, continue the appeal before appellate tribunal. Creditors. So correct is, जिस कोर्ट ने उसे इंसॉल्वेंट डिक्लेयर किया वही कोर्ट ऑफिशियल रिसीवर या असाइनी अपॉइंट करेगा एंड दे विल कंटिन्यू द लीगल प्रोसीडिंग्स. Who shall determine the amount of claim of creditor in insolvency process? It's by default resolution professional. Know the thought. Can an adjudicating authority order the liquidation of corporate debtor even after approving the resolution plan? Yes. अगर resolution plan का पालन नहीं हो रहा है, अगर उस तरीके से पेमेंट नहीं किया जा रहा, अगर उसके अंदर जो टर्म्स एंड कंडीशंस बताए उसका उल्लंघन हो रहा है, तो they can order liquidation. Yes. If the resolution plan is contravened, the adjudicating authority may order liquidation of corporate debtor even after approving on receiving application from a third party. No. Yes. Committee of creditor. No. No is wrong. So mean is yes if the resolution plan is not approved. What is the periodicity of submission of report by the company liquidator with respect to progress on winding up of tribunal of company to the tribunal? So once the compulsory winding up goes on, the liquidator has to regularly submit the report to NCLT, right? And that report is on quarterly basis. It has to submit on which basis? Quarterly basis. Mr. X, a resident of India, planned a tour of 15 days to visit Paris and to meet his niece living there. While returning to India, Mr. X was carrying with him rupees 30,000. Her niece told him that the limit is marked on bringing Indian INR while returning to India. So if you're coming from Nepal or Bhutan, you can bring up to 100 rupees. And if from any other place other than Nepal or Bhutan, you can bring up to 25,000 limit. So the correct limit is up to 25,000 rupees. In case of financing of a financial asset by more than one secured creditor, so again the matter goes to sufficient. Their secured creditor shall be entitled to exercise any rights conferred on him is agreed upon by the secured creditors representing 60% lessening minimum 60% in value of the amount outstanding as on the record date. This is with respect to section 13. Enforcement of security interest. So that's how the independent case studies also comes to an end. Now friends, let us discuss the descriptive questions, and in all we are on 18th question and totally we have 26 questions. So you can say more or 8 questions we need to discuss from this particular revision test paper for CA final. Now friends, when we see the very first descriptive question, which is based on case study, so it's not a direct question but it is based on case study, and it is with respect to section 180 subsection 1 clause C. Let us first see the question here. Dharma Limited, so it's a public company. Had it been a private company, the provisions of section 180 subsection 1 clause C was not applicable. In light of prospective development in the infrastructure of company, I have decided to borrow on long-term basis from financial institution. Why they specifically told long-term? Because those borrowings which are short-term in nature, right, are not included in this overall ceiling of 180 subsection 1 clause C. In the board meeting held on 15 September, following proposal of borrowing 2 crore rupees from financial institutions in the light of provisions on long-term basis was also presented for consideration. So the proposed amount is 200 lakh rupees or 2 crore rupees. As per the given information, in light of relevant provisions of Companies Act, examine the eligibility of the amount up to which board can borrow from financial institution and state the validity of the said proposal. They have given the paid up capital, means the proposal was kept on 15th of September. So we need to calculate the limit based on 31st March 2020. So they have given the three financial year details 18, 19 and 20. So this will be useful to us. Paid up capital, GR, P&L, secured as premium and secured loans already taken and the outstanding. These are the details which are available. So how we need to do this is see 85 lakhs plus 60 lakhs plus 20 lakhs plus 3 lakhs. So 1,68,000. This is the limit under section 180 subsection 1 clause C. From that already 40 lakhs is borrowed. So we can borrow, means board can borrow up to 1 crores 28 lakhs or 128 lakhs. Beyond that, if the board wants to borrow, then board resolution alone is not sufficient. You need to obtain shareholders approval by way of special resolution in the general meeting. And in this resolution, shareholders can also specify the next amount up to which the directors can borrow on their own. So, 2 crores borrowing in board meeting, it's fine. Board resolution is needed. But apart from that, members' resolution is also needed. Otherwise, it is absolutely invalid. As per section 180, subsection 1, clause C of Companies Act, the board of directors, without obtaining the approval of shareholders in a general meeting, can borrow money, including money already borrowed, up to the amount which does not exceed the aggregate of paid up capital, free reserves and securities premium. Such borrowing should not include temporary loans obtained from the company's bankers in ordinary course of business. Here free reserves does not include reserves which are set apart for any specific purpose. Since the borrowing decision is to be taken on 15 September, we need to take the limit on 31st of March. So Dharma Limited is entitled to borrow up to 1 crore 28 lakhs. So हमने calculation किया था through board of directors. As in the given case, the proposal of borrowing was up to rupees 2 crores, which is more than the eligibility to borrow. Therefore, Dharma Limited has to seek the approval of shareholders in the general meeting, which is must. And as the proposal of borrowing 2 lakhs from bank or finance was presented in board meeting without approval of shareholders in general meeting, therefore the said proposal is invalid. So up to the limit it is fine, but beyond when it goes to limit it is not perfect. So it is like this. Plus borrowings shall not exceed. So is it plus securities premium? If no, only board resolution. And if yes, along with board resolution, we require which resolution? Members resolution. And when you are taking these borrowings, this borrowing should not include any long-term borrowings. Include any long-term borrowing. So this was the first practical based on 180 subsection 1 clause C. Next, Mr. Sharif, who was KMP of XYZ Limited, retired on 12th May 2020. An examination of final accounts for the year ended 31st March 2020. The ROC found some serious irregularities in writing off of the huge losses of bed debts, and no satisfactory explanation was provided for the same from the company. In such a situation, the ROC wants some explanation from the company and Mr. Sharif. In light of provisions of Companies Act 2013, examine the situation and advise on the act of registrar seeking explanation from Mr. Sharif. Yes, 100%. See, Sharif retired on 12th May. So obviously, 31st March, the final accounts when 31st March. So for financial year 1920, he was a KMP. So the answer is with respect to when he was in position. So obviously, ROC can demand the information from them. No second thought to it. As per the provisions of section 206 of the Companies Act 2013, the ROC can call for any information or explanation or any other further documents related to company from the company or any officer if various things for deciding any matter of the company. Not only this, officers does not mean existing officers. Proviso to section 206 subsection 2 provides that where such information or explanation relates to any past period, the officers who had been in the employment of the company for such period, even though presently they are not in employment, at that point of time they were in employment, if so called upon by registrar to a notice served on him in writing, shall also furnish such information or explanation to the best of their knowledge. So in the given case, Mr. Sharif, the ex-manager of the company, can be called upon for such information explanation which was related to their period of service. And in case Mr. Sharif does not provide, then the penalty will be 1 lakh rupees plus 500 rupees per day the offence continues. This I think so we discussed earlier in MCQ also. Yeah. Right, so every officer will be punishable with the same. So that also needs to be kept in mind. Next, Mr. M, a member of XYZ Limited, filed an application before NCLT complaining of operation and mismanagement with respect to an agreement entered by XYZ, that is company, affecting the interest of company. Now, when there is operation and mismanagement, obviously NCLT is a power that NCLT may cancel the contract. Wide order passed, wide means through, order passed by NCLT under section 242 of Companies Act terminated the said agreement. The agreement was entered by Mr. H and G, who was MD and Executive Director of company, Mr. Rasikh, with whom XYZ Limited entered the agreement, filed a petition claiming the loss caused due to termination of the same agreement. Also state the legal position of Mr. H and G holding their place of office in the same situation. Examine with the given facts and address the terms in issues related to Companies Act. So basically this is again with respect to operation and mismanagement. Now NCLT 100% has the power to terminate the contract. So as per section 243 of Companies Act 2013, where an order made under 242 terminates, set aside or modifies an agreement which was entered by the company where in a manner prejudicial, detrimental, harmful, nuksankarak to the interest of company, such order shall not give rise to any claims whatsoever against the company by any person for the damages or compensation for loss of office or in respect of any other respect, either in pursuance of agreement or otherwise. So first thing is no claim. Second, no MD or other director or manager whose agreement is so terminated or set aside shall for a period of 5 years from the date of order terminated or setting aside the agreement without the leave of, that is permission of tribunal, be appointed or act as MD or director or manager of the company. Means he cannot be reappointed for next 5 years, and if he wants to be appointed during the next 5 years, we need to obtain the permission of NCLT. Accordingly, Mr. Rasik, with whom company entered the agreement, filed a petition claiming the loss caused due to termination of the said agreement. Further, Mr. H&G, MD and Executive Director of XYZ Limited, who entered agreement with Mr. Rasik, which was ordered to be terminated, shall not act as MD or Director or Manager of the company for a period of 5 years from the date of order terminating or setting aside the agreement without the leave of tribunal. So first, the agreement will be cancelled. They cannot continue as their position for the next 5 years. And during the next 5 years, if they want to get themselves appointed, then in that situation, it's compulsory for them to obtain the permission of of NCLT. Next case, Mr. Ingenious, who is registered as an intermediary, fails to enter into an agreement with his client and hence penalized by SEBI under SEBI Act 1992. Advise Mr. Ingenious as to what remedies are available with him against the order of SEBI. Means here, if Ingenious is considering that yes, he has made an offense and he is liable for penalty, then he need to make the penalty, payment of penalty. Means he agree with the order, then he has to make the payment of penalty. But in case if he is not willing to pay the penalty, means he is not satisfied with the order, he is aggrieved, he is dissatisfied, then yes, he can always prefer an appeal to Securities Appellate Tribunal. Let us go for the basic understanding of this. First, what is the penalty that can be levied? So, minimum 1 lakh rupees for each day the offence continues, up to maximum 1 crore rupees, whichever is less. And Mr. Ingenious has been penalized under the above mentioned provision. 2 remedies are available. One is appeal to SET and another is appeal to Supreme Court. The very first is appeal to SET. Then in this you can see that any person aggrieved by an order of SEBI made or by an order made by adjudication officer, and presently even for IRDA orders and PFRDA orders may prefer an appeal to a SET having jurisdiction in the matter. This appeal is to be done within 45 days from the date of receipt of copy. Every appeal shall be filed within a period of 45 days from the date on which the copy of order made by board or adjudicating authority is received by him, and it shall be in such form and be accompanied by such fee as may be prescribed. So it should be done in the appropriate form. Along with that, the copy of order is to be attached and also payment of fees. Now, if you fail to make an appeal within 45 days, SET may condone the delay. So, provided that the SET may entertain an appeal after the expiry of the said 45 days if it is satisfied that it was sufficient cause for not filing it within the period. On receipt of appeal, the SET may, after giving the parties to appeal an opportunity of being heard, pass such order thereon as it thinks fit, either confirming the order of adjudicating authority, changing or cancelling the order appealed against. यानी जो भी सेबी का ऑर्डर था उसको कैंसिल कर सकता है, कंफर्म कर सकता है या तो चेंज कर सकता है. The SEC shall send a copy of every order made by it to the board the parties to the appeal and to the concerned adjudication officer. And SEC shall always make an endeavor, prayas, effort that when the appeal is received within 60 days, they give the order of the same. So the appeal filed before SEC shall be dealt with by it as expeditiously, as soon as possible, with all precautions as possible, and endeavor, effort shall be made by it to dispose of the appeal finally within 6 months from the date of receipt of appeal. And second is, if further SEC order needs to be appealed, then within 60 days you can prefer an appeal to Supreme Court. Even if you fail to do within 60 days, then Supreme Court has a power to condone the delay and it may accept the appeal even after 60 days. So these are the two remedies which are there with respect to Securities Appellate Tribunal. Now friends, at this juncture, let me tell you that these appeal provisions are very important because appeal provisions comes in Companies Act in NCLT, comes in SEBI, comes in SCARA, comes in money laundering, comes in FEMA. So almost everywhere it comes in. So let us take an opportunity to fast have a recap of this appeal provisions of SEBI, because that will be helpful to us as a common logical understanding in all the economic laws to come. So hereby, let us take a glimpse of that lecture of appeal, which we already discussed in our routine lectures of SEBI and SCARA. So let's see that provisions with respect to appeal which are there in SEBI. So here we go with that particular revision. So now friends, let us start with the further provisions. And today, if I try to brief you out this particular whole chapter, how it goes, right? If we take the mind map of this particular chapter, then this chapter of is made up of two parts. One is the Act and another is the SEBI LODR, SEBI Listing Obligation and Disclosure Requirement. जो एक्ट है उसको मैंने कुछ पार्ट में ब्रेक किया है. एक सबसे पहले सब कुछ विद रिस्पेक्ट टू सेबी, दूसरा सब कुछ विद रिस्पेक्ट टू ऑल द लीगल कॉन्सेप्ट्स, तीसरा is with respect to Securities Appellate Tribunal, चौथा is with respect to penalty, and पांचवा is some sundry concepts. That's how this act is made up of. अब फिलहाल हम देख रहे हैं सेट. तो सेट में भी तीन मेन चीज है. एक, सेट का कंपोजिशन, यानी सेट में कौन होता है, सेट कैसे चलता है, ऑल दो स्टफ. सेकेंड कम्स द अपील प्रोसेस, एंड थर्ड कम्स द प्रोविजंस ऑफ स्पेशल कोर्ट्स. सो दिस इज ऑल द थ्री थिंग्स आर डन अप विद. इसमें से जो हो चुका है उसको मैं रेड टिक मार्क करता हूं. SEBI is done with, legal concepts is done with, composition is done with. So now today, in this we are starting with the appeal process. कि अगर हम सेट के खिलाफ अपील करते हैं तो how the whole process, जिसके बारे में हम कब से सब कुछ देख रहे हैं, how the whole appeal process will go, that is something we are going to discuss in today's session. आते में कोई लॉग ले लो so that you can keep on tracing that how the things are going on.
नाउ आगे सेबी में और लीगल कॉन्सेप्ट्स में कितनी सारी बार ये आया, दैट इज अपील टू सेट, या उसको ऐसा बोला जाता है अपील अंडर सेक्शन 15T. सो नाउ वी आर ऑन वेरी इंपॉर्टेंट कॉन्सेप्ट. 18th है ना ये. Now we are in the 19th concept. That is appeal to Securities Appellate Tribunal, Section 15T, A category, बिकॉज ये सेबी में भी है और स्कारा में भी है. नाउ सबसे पहला पॉइंट कम्स इज which orders can be appealed to SET. यानी सेट के खिलाफ आप कौन से ऑर्डर्स को अपील में लेके जा सकते हो. Following orders can be challenged before SET. यानी इन ऑर्डर्स के, ये ऑर्डर्स के खिलाफ अगर आप अग्रीड हो, अगर आप डिससेटिस्फाइड हो, तो यू कैन ऑलवेज प्रिफर एन अपील टू SET. ऑर्डर्स ऑफ एजुडिकेशन अथॉरिटी. एजुडिकेशन अथॉरिटी का ऑर्डर हो तो उसके खिलाफ आप कर सकते हो. ऑर्डर्स ऑफ सेबी, ऑर्डर्स ऑफ IRDA, ऑर्डर्स ऑफ पेंशन फंड रेगुलेटरी एंड डेवलपमेंट अथॉरिटी PFRD. तो फ्रेंड्स, ये लोगों ने जब ऑर्डर पास किया और कोई भी इंसान अगर इनके ऑर्डर से अग्रीड हो, इनके ऑर्डर से डिससेटिस्फाइड हो, अगर इनके ऑर्डर को से सेटिस्फाइड हो तो उसे कंप्लाई करे, और अगर इनके ऑर्डर से डिससेटिस्फाइड हो तो उनके खिलाफ सीधी उसे क्या करनी होगी, अपील करनी होगी. बट बेयर इन माइंड, व्हेन नो अपील, आप कब अपील नहीं कर सकते हो. कब आप नहीं कर सकते हो, देन when order is passed by adjudication authority या फिर सेबी या फिर IRDA या PFRDA, with द कंसेंट ऑफ पार्टीज. यानी कि फ्रेंड्स, हमेशा एक चीज आती है जो हमने आर्बिट्रेशन में भी देखा था कि अगर आप किसी से भी डिससेटिस्फाइड हो तो सबसे पहली चैलेंज आप उससे करते हो. वो अगर सॉल्व कर दे तो फिर कोई इश्यू नहीं होती, पर अगर वो सॉल्व ना करे तो ये हायर अथॉरिटीज के पास जाते हैं. तो अगर सेबी ने ऑर्डर पास किया तो सबसे पहले आप सेबी को कहो. अगर सेबी नहीं मानता है तो फिर आप फर्दर जाओ, पर अगर सेबी मान जाता है या आप सेबी के ऑर्डर से सहमत हो तो फिर नो नीड टू मूव अहेड. एंड एक एक्स्ट्रा चीज मैं लिखता हूं, when any leniency approach is used such as कंपोजिशन ऑफ ऑफेंस। यानी फ्रेंड्स हमने लीगल कॉन्सेप्ट्स में कॉन्सेप्ट पढ़ा था कि आप इम्प्रिजनमेंट की जगह पे या प्रोसिक्यूशन की जगह पे पैसे देके छूट सकते हो, या फिर आपके ऊपर जो फाइन लगे उस फाइन को भी आप क्या करवा सकते हो, रिड्यूस। तो अगर फ्रेंड्स आपने कोई भी प्रकार से ऐसे लीनियंसी अप्रोच यूज किया हो कानून का, तो फिर आप फर्दर कोई अपील कर सकते नहीं। दैट इज टू बी बेड इन माइंड। Then the next point comes is legal process. यानी कि ये जो अपील की बात आती है, राइट, ये अपील कैसे करते हैं। पर मैं चाहता हूं ये अगर हम देखें उसके पहले आप खाली एक मिनट इतना नोट डाउन कर दो, बिकॉज दिस इज वेरी इंपॉर्टेंट पोर्शन। हम धीरे धीरे आगे बढ़ेंगे, साथ साथ मैं आपको जितना बोलता हूं उतना नोट डाउन भी करते जाओगे, राइट। सो इट शुड बी गोइंग जस्ट लाइक अ लेक्चर। हमें कोई यहां भागा भागी नहीं। नोट डाउन एकदम परफेक्टली। ओके, नाउ मूविंग टुवर्ड्स अ लीगल प्रोसेस कि अगर अपील करने की हो तो अपील किस तरीके से की जाती है। देन person aggrieved by adjudicating authority, yes, SEBI, या फिर पेंशन फंड रेगुलेटरी डेवलपमेंट अथॉरिटी, उनके ऑर्डर से जो पर्सन अग्रीव्ड है वो, राइट। एंड सामने Securities Appellate Tribunal, that is SET. राइट, तो जो भी इंसान अग्रीव्ड है उससे अपील करनी होगी। अपील या एप्लीकेशन। तो उसके अंदर खास ध्यान क्या रखना है, प्रिस्क्राइब फॉर्म, plus you need to annex documents plus time limit plus fees. फॉर्म, डॉक्यूमेंट, टाइम लिमिट एंड फीस. फिर डिटेल में देखते हैं. फिर जैसे ये बात सेट के पास जाएगी, सेट टू डिसाइड द डेट ऑफ हियरिंग. वो हियरिंग की डेट डिसाइड करेंगे. उसके बाद सेट विल सर्व द नोटिस ऑफ हियरिंग. सेट टू सर्व द नोटिस ऑफ हियरिंग. उसके बाद सेट विल कंडक्ट द हियरिंग. set to conduct the hearing. And उसके बाद set to serve copy of order to all parties. तो जितनी भी पार्टीज है उन सबको सेट क्या करेगा, ऑर्डर की करेगा. सो दिस इज हाउ फ्रेंड्स इट गोस. सो अगर मैं नंबर दूं तो अपील 1, डेट ऑफ हियरिंग 2, नोटिस हियरिंग एंड कॉपी ऑफ ऑर्डर. राइट. तो मैं पहले आपको कहता हूं, इतना जस्ट पहले नोटबुक में एक डायग्राम जैसा बना, फिर हम इसके एक एक पॉइंट को देखते हैं. जो नोट्स है वो भी मैं अलग से लिख देता हूं. पहले इतना डायग्राम एक बनाओ. फ्रेंड्स एक बार आप लिख लेते हो तो फिर हम इसके एक पॉइंट को देखना शुरू करते हैं. Now, moving on to the very first that is note A, documentation. तो उसमें आता है applicant has to attach all necessary documents to support the application और उसे सारे नेसेसरी डॉक्यूमेंट्स को अटैच करने होंगे. Documents to include certified copy of order to be challenged. That is order of adjudicating authority या order of SEBI या ऑर्डर ऑफ IFD या ऑर्डर ऑफ पेंशन फंड रेगुलेटरी एंड डेवलपमेंट अथॉरिटी एंड अदर डॉक्यूमेंट्स एज दे डीम. सो ये सारे डॉक्यूमेंट्स की कॉपी हमें क्या करनी होगी? देन यू कैन से हमें अटैच करनी होगी. फिर हम नोट 2 के ऊपर आते हैं. नोट 2 इज विद रिस्पेक्ट टू टाइम, कि कितने टाइम में अपील होनी चाहिए. मैं आपको बाद में लिखने का समय देता हूं. within 45 days of the receipt of order of adjudication authority, yes SEBI, या PF set may entertain an appeal after the expiry of CD period if it is satisfied that there was sufficient cause for not filing the appeal in time. यानी कि अगर आप सेबी को खास करके रिक्वेस्ट करते हो तो सेट 45 डेज के बाद भी उसे एक्सेप्ट करेगा, पर हमें प्रूव करना होगा और सेबी सेट सेटिस्फाइड होना चाहिए कि देयर वाज रीजंस बियॉन्ड द कंट्रोल ऑफ द पर्सन. तो एक मिनट फ्रेंड्स, अब ये नोट 1 and 2 भी कॉपी करें. ये भी लिख लेना। अब फ्रेंड्स नोट 3 के ऊपर जाते हैं कि जो ये हियरिंग होता है वो हियरिंग कैसे पूरा किया जाता है। नाउ वेरी इंपॉर्टेंट प्रोसेस वी आर गोइंग टू डिस्कस। Hearing process. Set shall exercise the powers conferred यानी legally granted to it। यानी सेट को सारे पावर्स सिविल कोड के यूज करने चाहिए जो उसको मिले। एंड इसके ऊपर पूरा हम इसके बाद का टॉपिक पूरा देखने वाले। वी आर गोइंग टू सी इट कंप्लीटली। इट्स द नेक्स्ट टॉपिक। दूसरा, द अपील shall be dealt with by SEBI as expeditiously as possible and endeavor shall be made by it to dispose of the appeal finally within 6 months from date of its receipt। पूरा समझने का प्रयास करते हैं। पहले तो सेबी को जितना हो पाए उतना फास्ट 6 महीने के अंदर फाइनल ऑर्डर पास करने का प्रयास करना चाहिए, राइट। यानी जैसे तैसे नहीं तो सी कुछ वर्ड्स है। डेल्ट विथ यानी कंडक्ट हियरिंग। एक्सपीडिशियसली का मतलब आपको फास्ट करना है, बट फास्ट करना इन द सेंस फास्ट तो करना ही है, पर इसके साथ साथ जितनी सावधानी आपको रखनी है वो सारी सावधानी यू नीड टू कीप। एंडेवर यानी सारे एफर्ट्स करने होंगे, बेस्ट एफर्ट शुड बी डन। डिस्पोज ऑफ द अपील का मतलब pass an order. So this is how the hearing process needs to be conducted. जस्ट फ्रेंड्स एक ये भी कॉपी करो. अब फ्रेंड्स नेक्स्ट वर्किंग नोट पे जाते हैं इसकी. दैट इज इसका जो ऑर्डर आता है वो. ऑर्डर ऑफ set. Right, now let us try to understand this. First point, set by order may confirm or modify or set aside order of AA या सेबी या IRDA या PFI. यानी सेट जिसके ऑर्डर के खिलाफ अपील किए उनके ऑर्डर को अगर सेट को परफेक्ट लगता है तो सेट विल कंफर्म. अगर सेट को थोड़े बहुत चेंजेस करने लायक लगते हैं तो सेट विल मॉडिफाई. और सेट को ऐसा ही लगता है कि जो अथॉरिटी है एडजुडिकेटिंग है सेबी उन्होंने थोड़ा सा भी ध्यान नहीं रखा है तो दे विल सेट असाइड, दे विल कैंसल द ऑर्डर. सेकेंड, set shall serve copy of order to A all parties to appeal and दूसरा B adjudicating authority या SEBI या IRDA and set order on question of law and question of facts. यानी जहां इंटरप्रिटेशन का सवाल इन्वॉल्व होता है इट इज क्वेश्चन ऑफ लॉ एंड जहां फैक्चुअल चीजें हो पैनल्टी हो सकता है इट्स अ क्वेश्चन ऑफ फैक्ट. तो क्वेश्चन ऑफ लॉ हो तो अपील तो सुप्रीम कोर्ट, चाहो तो अपील कर सकते हो. क्वेश्चन ऑफ फैक्ट्स हो तो नो फर्दर अपील, इट विल बी फुल एंड फाइनल. यानी वो एकदम फुल एंड फाइनल होगी, उसके खिलाफ और फर्दर कोई अपील की जाएगी So this is how we end up with this part, that is the position with respect to order of set. So now you take down this also. Then we move to the next topic that I said you, that what are the powers of set available with set. Now let us read from the notes. Notes please. या अब मॉड्यूल में से पढ़ते हो देन ऑल्सो नॉट एन इश्यू. मैं आपको आज के लेक्चर के एंड में नोट्स भी अगर आपके पास है तो उसमें से पढ़ो, या फिर आज के लेक्चर के एंड में मैं आपको मॉड्यूल के कुछ पेजेस बता दूंगा जितने आप पढ़ सकते हो. हम तो यहाँ मॉड्यूल से भी ज्यादा डिटेल में देखते हैं. सबसे पहले अपीलेबल ऑर्डर्स, यानी orders which can be challenged to set. तो एक तो एडजुडिकेटिंग ऑफिसर का ऑर्डर, जो एडजुडिकेशन प्रोसेस होता है, वो ऑर्डर ऑफ सेबी या IRDA या ऑर्डर ऑफ PFRDA. बिकॉज अभी तक IRDA PFRDA का अलग से ट्रिब्यूनल ही बना, तब तक इनके ऑर्डर्स भी सेट एंटरटेन करता है. फिर खास ध्यान क्या रखना है, नो ऑर्डर शेल लाई टू सेट फ्रॉम एन ऑर्डर मेड विद द कंसेंट ऑफ पार्टीज. यानी कि जब पार्टीज को जब ऑर्डर पास किया और तब पार्टीज को कहा जाता है कि डू यू हैव एनी प्रॉब्लम, और तब पार्टीज कुछ नहीं कहती, तो इट मीन्स दैट दैट ऑर्डर इज पास विद द कंसेंट ऑफ पार्टी. राइट, तो फिर आप फर्दर कोई चैलेंज कर सकते नहीं. द अपील शेल बी फाइल्ड विद इन 45 days फ्रॉम द डेट ऑन विच अ कॉपी ऑफ ऑर्डर इज रिसीव्ड बाय द अग्रीव्ड पर्सन. अग्रीव्ड का मतलब बाय द डिससेटिस्फाइड पर्सन, तो उसके 45 days में अपील कर सकते हैं. एंड the set may entertain an appeal after the expiry of the said if it is satisfied that there was sufficient cause for not filing the appeal within that period. So 45 days के बाद भी अगर अपील को एड्रेस करना हो, I mean अपील के बारे में कुछ कहना हो, तो भी वो कह सकते हैं, बट नॉर्मली within 45 days this appeal should be handled. That needs to be taken care. What is the process? It should be in form as may be prescribed, and it should be accompanied by the fees as may be prescribed. What this prescribed means? Prescribed by CG या फिर set. फिर the set में after giving the parties an opportunity of being heard, pass thereon as it thinks fit, confirming, modifying or setting aside the order appeal again. Setting aside का मतलब क्या? कैंसिल. तो कुछ वर्ड्स आज हम लिखेंगे ऑब्वियस, उसमें से एक वर्ड आएगा सेट असाइड. ओके, उसके बाद द सेट शैल सेंड अ कॉपी ऑफ एवरी ऑर्डर मेड बाय टू सेबी, IRDA, PFRDA, एडजुडिकेटिंग अथॉरिटी एक्सेट्रा एंड लास्ट ये 5th पॉइंट रीड करना, एक्सपेडिशियसली वाला। सारे में वर्ड्स मैंने सिंपल मीनिंग आगे तो लिखवा है, एंड में मैं एक पूरा लिस्ट भी बनवा दूं। अब फ्रेंड्स वापस से इस डायग्राम के ऊपर आ जाता है कि यहां पे हमने जो मेन एक चीज देखी, सेट शेल कंडक्ट हियरिंग। अब ये हियरिंग जो करता है यानी नोट 3, फिर हम नोट 3 में गए तो हमने ये वाला पॉइंट देखा था, और जिसमें हमें बोला कि जो उनके पावर्स है वो हम नेक्स्ट टॉपिक में देखते हैं। तो नाउ वी आर डिस्कसिंग द मेन कॉन्सेप्ट दैट व्हाट आर द पावर्स अवेलेबल विद सेट। यानी सेट के पास जब कोई मामला आता है, कोई ट्रायल आता है, कोई सूट आता है, कोई केस आता है, कोई अपील आती है, कोई एप्लीकेशन आती है, तो सेट उसे डिस्पोज ऑफ करे, यानी उसके ऊपर फाइनल ऑर्डर पास करे। क्योंकि फाइनल ऑर्डर पे आने के लिए सेट के पास कौन कौन से पावर्स अवेलेबल है, दैट वी आर मेनली गोइंग टू सी नाउ इन दिस पर्टिकुलर टॉपिक। The topic is the 20th number topic, procedure and powers of set. Procedures and powers of set. A category. सेबी एंड स्टार, ये दो। अब सबसे पहले बात करें तो लीगल पोजीशन ऑफ सेट, यानी सेट की लीगल पोजीशन क्या होगी। तो सेट shall be deemed to be quasi कोर्ट, यानी हम सेट को कोर्ट का दर्जा देते हैं। यानी जो पोजीशन एक कोर्ट की होती है उसी पोजीशन हमने किसको दी, हमने सेट को दी। दूसरा, ऑल प्रोसीडिंग्स conducted by set shall be quasi judicial proceedings। सो सेट की जो प्रोसीडिंग्स होगी वो हम क्या ट्रीट कर देंगे, सेबी की जो सेट की जो प्रोसीडिंग्स होगी उसे हम जुडिशियल प्रोसीडिंग्स ट्रीट कर देंगे, तो ही सेट के द्वारा पास किए गए ऑर्डर को एनफोर्सिबल हो सकता है। बिकॉज ऑफ इट सेट ऑर्डर is enforceable. So then only the orders which are passed will be enforceable. Now the second point comes. The second point comes is with respect to प्रोसीजर। राइट, फिर मैं आपको लिखने के लिए टाइम देता हूं पूरा। तो फर्स्ट इज सेट इज नॉट bound by the process laid down by Code of Civil Procedure 1908. दूसरा, set shall have powers to regulate their own procedure, including the places at which they shall have their say. So सारा procedure, they are not required to be bound by the exact procedure which is given by the Code of Civil Procedure. तो फास्ट इनका काम हो सकता है, प्लस वो कहाँ बैठे, कैसे काम करें, वो सब कुछ वो अपने आप डिसाइड कर सकते हैं. हाँ, उन्हें खाली एक चीज का ध्यान रखना होगा, set is bound to be guided by the principles of natural justice, by the principles of natural justice, that is opportunity of being heard shall be given to all the parties connected. So opportunity of being heard will always be given to all the parties too. So खास करके इतना फ्रेंड्स पहले नोट डाउन करो, फिर हम पावर्स के ऊपर जाते हैं कि सेट के पास कौन से पावर्स होंगे टू कम अप विथ. Then friends, after the procedure, now we come to the point of powers. Right, the powers which are available. तो they say कि एक सिविल कोर्ट के पास जब कोई मामला आता है और सिविल कोर्ट के पास उस मामले को सुलझाने के लिए जितने पावर्स अवेलेबल होते हैं, वो सारे पावर्स एक सेट के पास भी अवेलेबल होते हैं. तो फर्स्ट, Code of Civil Procedure 1908 has vested powers on civil court to exercise with वाइल्ड, ट्राइंग अ सूट। यानी उनके पास जब कोई केस आता है तो उनके पास पावर्स, लॉ सेज सेम powers of civil code are vested on set for trial of suits। यानी सेट जो ट्रायल जो करेगा, राइट, उसके अंदर सेम पावर्स आएंगे एज आर वेस्टेड ऑन द सिविल कोड, राइट। तो सेम पावर्स विल बी गिवन टू सेट। powers with respect to following: A, सारे डॉक्यूमेंट्स रिलेटेड पावर, राइट। कैसे डॉक्यूमेंट्स रिलेटेड पावर, आप ऐसे याद रखना। फिर मैं आपको पूरा कॉपी करने के लिए समय देता हूं। डिस्कवरी एंड प्रोडक्शन ऑफ डॉक्यूमेंट्स, यानी कि कोई भी प्रकार के डॉक्यूमेंट्स, रिकॉर्ड्स, इंफॉर्मेशन, लेजर, कुछ भी हमें चाहिए, कोई रिपोर्ट चाहिए, तो दे कैन ऑलवेज डिमांड इट। Requiring evidence on affidavit। अगर उन्हें और उस डॉक्यूमेंट की टेनासिटी को चेक करने के लिए, उसकी और वैलिडिटी को चेक करने के लिए अगर सेट चाहे तो सेट ऐसा कह सकता है कि ये डॉक्यूमेंट्स जो है, राइट, वो आप एफिडेविट पे ही हमें प्रोड्यूस करो। रिक्विजिशनिंग, मैं वो वर्ड्स में डाल दूं, टफ वर्ड्स वाले में। जो हमने कहाँ गया वो लिस्ट, जो हमने एक लिस्ट बनाया ना जिसमें, हाँ, जो मैं आपको एंड में लिखवा देता हूं सारा। रिक्विजिशनिंग, requisitioning any public records from any public authorities, यानी कोई भी पब्लिक अथॉरिटी के पास से रिकॉर्ड्स चाहिए कोई भी इंसान के बारे में, तो बिंदास वो लोग डिमांड कर सकते हैं। पहले इतना फ्रेंड्स नोट डाउन करो, तीन चीजों के बारे में। पहले डॉक्यूमेंट्स के बारे में, तो डॉक्यूमेंट्स में कोई भी डॉक्यूमेंट, रिकॉर्ड कुछ भी मांग सकता है, फर्स्ट थिंग। दूसरा क्या था, कोई एविडेंस जो है उसे एफिडेविट करवाने के लिए बोल सकते हैं। एंड तीसरा क्या है कि कोई भी बैंक के कोई भी जगह से अगर पब्लिक रिकॉर्ड चाहिए उस इंसान के बारे में, तो भी वो लोग उसे रिक्विजिशनिंग, वो लोग डिमांड कर सकते हैं, कोई दिक्कत होगी। सो फ्रेंड्स, यहां पे क्या होगा, मॉड्यूल की सेम लैंग्वेज है, पर हम उसको खाली थोड़ा ऊपर नीचे कर रहे हैं। मैं उसको ग्रुप सारे में डाल रहा हूं एंड लैंग्वेज इज केप्ट वन एंड द सेम। I hope it is copied। फिर अब हम क्या करते हैं, पर्सन्स रिलेटेड कुछ पावर्स को देखते हैं। ये मैं यहां पे रखता हूं। तो पर्सन रिलेटेड पावर में क्या आएगा? समॉनिंग एंड एनफोर्सिंग अटेंडेंस ऑफ एनी पर्सन, यानी कोई भी इंसान को वो लोग सेट में पर्सनली प्रेजेंट होने के लिए बोल सकते हैं. समॉनिंग यानी इनवाइटिंग, लीगल इन्विटेशन. सेकेंड, इश्यूइंग commissions in order for एग्जामिनेशन ऑफ विटनेसेस, यानी मौका वारदात पे कोई गवाह मौजूद हो, राइट, जिसके पास से इंफॉर्मेशन, उसके पास ही इज एक्वेंटेड विद द इंफॉर्मेशन, ऐसा कोई भी इंसान हो तो उसे हम क्या कर सकते हैं? पेश होने के लिए बोल सकते हैं. जैसे वो आते हैं एग्जामिनेशन ऑफ पर्सन्स ऑन, आते हैं तो उनकी पूछताछ कर सकते हैं. एग्जाम, ये मैंने फ्रेंड्स आपके इन्वेस्टिगेशन, ये जो पावर्स ऑफ सेबी थे ना, उसके अंदर मैंने डिटेल में समझाया था कि उनकी पूछताछ की जाएगी. द नोट्स विल बी टेकन ओवर, देन इट विल बी रेड ओवर, एंड वंस इट इज रेड ओवर, इट विल बी अ वैलिड एविडेंस व्हिच कैन बी प्रेजेंटेड इन द कोर्ट ऑफ लॉ. तो दिस आर सम पॉइंट्स व्हिच आर विद रिस्पेक्ट टू पर्सन्स, यानी कि विद रिस्पेक्ट टू इंसान. फिर तीसरा, हम प्रोसेस ओरिएंटेड कुछ पावर्स को देखते हैं. प्रोसेस ओरिएंटेड पावर्स में सबसे पहला पॉइंट आता है डिसमिसिंग एन एप्लीकेशन फॉर डिफॉल्ट. इसका मतलब क्या फ्रेंड्स? हमने देखा था कि कोई भी प्रकार की अपील करनी हो तो फॉर्म, प्रिस्क्राइब डॉक्यूमेंट्स, प्रिस्क्राइब फीस एंड प्रिस्क्राइब टाइम लिमिट भी होनी चाहिए. अगर फॉर्म सही नहीं है, सही डॉक्यूमेंट्स अटैच नहीं किए, फीस कम भरी है या टाइम लिमिट लैप्स हो चुका है, तो सेट हैज अ पावर टू डिसमिस यानी रिजेक्ट द एप्लीकेशन. और उसमें बताएगा क्यों एप्लीकेशन को रिजेक्ट किया. अब मान लो फीस नहीं भरी थी तो एप्लीकेशन को रिजेक्ट किया. अब सामने वाला फीस भरता है तो क्या बाद में अगेन दैट एप्लीकेशन में कैन बी एक्सेप्टेड? यस, पर उस एप्लीकेशन को एक्सेप्ट करना हो तो पहले जो डिसमिसल ऑर्डर था उसे सेट असाइड करना होगा. तो सेकेंड पॉइंट, सेटिंग असाइड द dismissal order of an application which was dismissed due to default, right? ऑर्डर को क्या करना होगा? कैंसिल करना पड़ेगा. दैट इज फॉर श्योर. तीसरा जो पॉइंट है, राइट, द थर्ड पॉइंट, वो क्या आएगा? डिसाइडिंग एन एप्लीकेशन एक्स पार्टी. व्हाट इज मीनिंग ऑफ एक्स पार्टी? दैट इज एक ही इंसान को सुन के डिसीजन लेना. जैसे दो पार्टीज ने केस किया था, एक्स एंड वाई ने, तो दोनों को सेट ने बुलाया था पर एक्स आया ही नहीं, राइट. तो सेट के पास पावर है कि वो वाई यानी एक ही पार्टी को सुन के अपना जजमेंट दे सकते हैं. दैट इज डिसाइडिंग एन एप्लीकेशन एक्स पार्टी. बट मान लो बाद में वाई आया, सॉरी एक्स आया और एक्स ने रीजंस दिए कि इट वॉज बियॉन्ड द कंट्रोल, राइट, एंड बिकॉज ही was unable to remain present, और अब सेट उन्हें सुनना चाहता है, वो एक्स को सुनना चाहता है. तो सेट के पास पावर है कि उसने पहले जो एक्स पार्टी ऑर्डर पास किया उसे अब क्या करे? सेट असाइड करे. सेटिंग असाइड द एक्स पार्टी ऑर्डर्स पास्ड. उन्होंने पहले जो एक्स पार्टी ऑर्डर पास किए थे उन्हें क्या कर सकते हैं? सेट असाइड कर सकते हैं, फिर वो सारी चीजों को वापस से सुन सकते हैं, राइट। तो रिव्यूइंग इट्स ओन डिसीजंस, एंड एक लास्ट आप कह सकते हो एनी अदर मैटर which may be prescribed government by way of notification in official gazette of India, right। इस तरीके से पावर्स दिए गए। तो पहले मैं चाहता हूं ये आप ये पर्सन वाले पावर को कॉपी डाउन करो। पहले 1 मिनट में आपको डॉक्यूमेंट पावर को कॉपी कर लो अगर रह गया हो तो, फिर मैं आपको इंसान रिलेटेड पावर्स देता हूं। एकदम डिटेल में कॉपी कर लेना, एकदम सही तरीके से। एग्जाम अगर आप ऐसे लिख के आओगे तो इट वाज 100% इट इज परफेक्ट, कोई दिक्कत आएगी। अब प्रोसेस रिलेटेड पावर्स कॉपी करो। कर लिया। एंड अब ये पावर्स वाला आंसर अगर आपको एग्जाम में पूछते तो आपको वो ऑपरेशन ऑफ बेंच वाला भी लिखना होगा। यानी हमने क्या क्या देखा, लीगल पोजीशन देखा, फिर प्रोसीजर देखा, एंड फिर पावर्स देखे। एंड नाउ इसके अंदर आप और क्या लिख के आओगे एग्जाम के वक्त, देन यू कैन से डी वाला पॉइंट, प्रोविजंस विद रिस्पेक्ट टू बेंचेस, जो मैंने आपको पूरा पहले समझा दिया है। तो मैं यहां पे कॉपी करता हूं, आपको सिर्फ वो नोट डाउन करना है। फिर अगर आपको कोई डाउट हो तो आप मुझे पूछ सकते हो। मैं 1 मिनट आपके लिए पेस्ट करके रखता हूं। अब अभी वापस से उसे कॉपी करोगे और उसे समझने का प्रयास भी करोगे। स्टार्ट कॉपिंग दिस, उसी आंसर का पार्ट है। जस्ट इतना कॉपी करो सो दैट एक रिवीजन भी हो जाएगा और इस आंसर में लिखना भी है. कोई डाउट आता है तो यू कैन आस्क मी. लिख लिया फ्रेंड्स. सो नाउ इसको हम बाद में वापस से जब रीड करते हैं तब मैं आपको डिटेल में समझा देता हूं. आई होप सो आपने ये लिख लिया है. तो नाउ लेट अस स्टार्ट द रीडिंग ऑफ दिस आंसर. तो मैं तभी ये रिवाइज भी करवा देता हूं. प्रोसीजर्स एंड पावर्स ऑफ सेट. Very, very important. The set shall not be bound by the procedures laid by Code of Civil Procedure 1908. यानी Code of Civil Procedure 1908 में जो exact situations दी है प्रोसीजर, उससे वो बंधा हुआ नहीं है. वो अपने आप अपने पावर्स को डिसाइड कर सकता है. हाँ, पर वो एक चीज से 100% बंधा हुआ है, दैट इज प्रिंसिपल्स ऑफ नेचुरल जस्टिस. वो तो उसे करना ही पड़ेगा. एंड इसे नॉर्मली हम कहते हैं रूल ऑफ नेचुरल जस्टिस. इसे तो फॉलो करना ही है. प्लस द सेम पावर्स एज आर वेस्टेड इन अ सिविल कोड. यानी जैसे फ्रेंड्स मैंने आपको आगे समझा ना कि सिविल कोड के पास जब कोई मैटर आता है और उस मैटर को सॉल्व करने के लिए जो पावर्स सिविल कोड के पास होते हैं वो सारे के सारे पावर्स यहां पे सेट के पास भी अवेलेबल होते हैं. राइट. क्यों ऐसा? देन द रीजन इज हियर. सेट shall be deemed to be a civil code, and every proceeding before the set shall be deemed to be a judicial proceeding. ये दो रीजन. राइट. पहला रीजन क्या है कि सेट इज डीम्ड सिविल कोड एंड डीम्ड टू बी जुडिशियल प्रोसीडिंग्स. एंड कौन कौन से ऐसे तो पावर्स हैं तो हम कह सकते हैं, मैंने आपको ये अलग अलग पूरे समझाए. राइट. फर्स्ट पावर इज सबॉर्डिंग एंड एनफोर्सिंग द अटेंडेंस ऑफ एनी पर्सन एंड, यानी कि कोई भी इंसान को वो पर्सनली फिजिकली प्रेजेंट होने के लिए बोल सकते हैं और उनकी पूछताछ कसम खिलवा के कर सकते हैं. रिक्वायरिंग द डिस्कवरी ऑफ एंड प्रोडक्शन ऑफ डॉक्यूमेंट्स. ओके, डॉक्यूमेंट्स मंगवा सकते हैं. रिसीविंग एविडेंस ऑन एफिडेविट. इश्यूइंग कमीशंस फॉर एग्जामिनेशन ऑफ विटनेस, यानी वो पूछताछ कर सकते हैं, अपने डिसीजन को चेंज कर सकते हैं. डिसमिसिंग एन एप्लीकेशन फॉर डिफॉल्ट और डिसाइडिंग इट एक्स पार्टी, यानी अगर कोई एप्लीकेशन गलत हो तो उसे रिजेक्ट कर सकते हैं. अगर कोई इंसान नहीं आता है तो एक पार्टी को सुन के एक तरफा ऑर्डर पास कर सकते हैं. उन्होंने पहले कोई एप्लीकेशन को रिजेक्ट किया, वो एक तरफा ऑर्डर पास किया होगा, उस ऑर्डर को वो सेट असाइड यानी कि वो कैंसल कर सकते हैं. ये सब फ्रेंड्स मैंने आपको डिटेल में बता दिया ना अभी आगे. राइट. अब चीजें जो है वो पूरी बेंच रिलेटेड मैंने आपको सेट के अंदर भी डिटेल में समझाते हैं. यहाँ वापस से पढ़ते हैं. When benches are constituted, the presiding officer of set may from time to time make provisions as to distribution of business amongst the benches and also matters to be dealt with. So कौन सा काम कौन करेगा, किस बेंच में होगा, वो भी वो डिसाइड करता है. फिर सेट या किसी की एप्लीकेशन पे मेंबर्स को भी ट्रांसफर कर सकता है या बेंच को भी ट्रांसफर कर सकता है. ऑन एन एप्लीकेशन ऑफ एनी ऑफ द पार्टीज and after the notice to the parties and after hearing such of them as he may desire to be heard or on its own motion. Right? Without such notice, the presiding officer of the set may transfer any case pending before any bench for disposal to any other bench. And अगर ऐसा हो कि 3 मेंबर की बेंच होगी या 5 मेंबर की बेंच होगी, ये सभी आगे हमने डिस्कस किया कि बेंच में बी ऑफ इवन नंबर और बेंच में बी ऑफ ऑड नंबर, राइट? तो अगर इवन नंबर की बेंचेस है तो अराइविंग एट अ डिसीजन माइट बी डिफिकल्ट, कंसेंसस नहीं आ रहा। यानी मान लो 2 मेंबर की बेंच है और एक मेंबर कह रहे हैं हाँ, दूसरे मेंबर कह रहे हैं ना, या 4 मेंबर की बेंच है, 2 मेंबर कह रहे हैं हाँ, 2 मेंबर कह रहे हैं ना, तो दे आर अनएबल टू अराइव एट अ डिसीजन, राइट? तो वो पॉइंट रेफर किए जाएंगे प्रिसाइडिंग ऑफिसर को। फिर प्रिसाइडिंग ऑफिसर या तो खुद इन्वॉल्व हो, एक मेंबर को इन्वॉल्व कर देगा या एक से ज्यादा मेंबर्स को इन्वॉल्व कर देगा। इन शॉर्ट वो बेंच को इवन नंबर से ऑड नंबर कर देगा। फिर वो सारे पुराने नए मेंबर्स मिलजुल के उन पॉइंट्स के ऊपर डिस्कशन करेंगे एंड दे विल अराइव एट अ डिसीजन। सो रीड दिस पॉइंट, इफ अ मेंबर ऑफ अ बेंच ऑफ सेट consisting of 2 members differ in opinion on any point, they shall state the point or points on which they differ and make a reference to the presiding officer of the set, who shall either hear the point or points by one or more of the other members of the set, and such point or points shall be decided according to the opinion of the majority. So majority के opinion पे आना बहुत जरूरी है. So this is one of the very crucial thing which you should always note down. Now friends, the next provision, point number 21 for this particular part C is appeal to Supreme Court. Again, this is A category. Right. Now, what is basically this appeal to Supreme Court? तो सेट ऑर्डर क्वेश्चन ऑफ फैक्ट या क्वेश्चन ऑफ लॉ। क्वेश्चन ऑफ फैक्ट यानी 3-4 चीजें इन्वॉल्व हो कि पेनल्टी 1 लाख रुपए नहीं, उससे कम ज्यादा होनी चाहिए। दैट इज फैक्चुअल बेस्ड ऑन द फैक्ट्स एंड सर्कमस्टेंसेस ऑफ द केस। तो in that situation, said decision is full and final. So no further appeal to सुप्रीम कोर्ट को कोई फर्दर अपील होगी नहीं। बट इफ इट्स अ क्वेश्चन ऑफ लॉ, यानी कोई इंटरप्रिटेशन का क्वेश्चन इन्वॉल्व हो, कोई मामला इनसाइडर ट्रेडिंग का हो, अब ऐसी बात है कि ये इनसाइडर ट्रेडिंग है या नहीं, ये वो डिसाइड नहीं कर पा रहे, तो क्वेश्चन ऑफ लॉ हो तो एनी पर्सन अग्रीव्ड यानी डिससेटिस्फाइड बाय set order may prefer an appeal to Supreme Court. तो वो इंसान हमेशा सुप्रीम कोर्ट को क्या कर सकता है? अपील कर सकता है। सबसे पहली चीज, फॉर्म। दूसरा डॉक्यूमेंट्स में क्या आएगा? सर्टिफाइड कॉपी ऑफ सेट ऑर्डर। पहले इतना कॉपी करो फ्रेंड्स, सर्टिफाइड कॉपी ऑफ सेट ऑर्डर। पेमेंट ऑफ फीस एंड टाइम लिमिट जो है वो with days of receipt of copy of order of set यानी 60 डेज में सुप्रीम कोर्ट में condone delay. What is the meaning of condone delay? That is to grant extension beyond 60 days फॉर सफिशिएंट रीजन, यानी जेन्युइन रीजन हो तो 60 डेज में अगर आप अपील नहीं कर पाए तो सेट जो है सॉरी सुप्रीम कोर्ट जो है वो उस मैटर को कंडोन करेगा एंड उसके बाद वो आपको एक्सेप्ट आपके डिलेड अपील को भी वो एक्सेप्ट कर सकता है, उसमें कोई दिक्कत होगी नहीं. एंड इतना खाली लिख लो, फिर फ्रेंड्स सुप्रीम कोर्ट ऑर्डर, सुप्रीम कोर्ट में बाय ऑर्डर कंफर्म, यानी उनके मुताबिक सेट ने जो ऑर्डर पास किया था वो सही है, या फिर वो सेट के ऑर्डर को मॉडिफाई भी कर सकते हैं. एंड अगर उन्हें ऐसा लग रहा है कि सेट ने ध्यान रखा ही नहीं है, सेट ने एकदम खराब तरीके से ऑर्डर पास किया है, तो वो सेट के ऑर्डर को सेट असाइड भी कर सकते. एंड वॉट एवर विल बी द ऑर्डर ऑफ सेट दैट विल बी फुल एंड Supreme Court that will be full and fine. So just take a last E वाला point add कर दो in the point of Supreme Court. So हमारा ये पूरा आंसर क्या हो जाएगा, कंप्लीट हो जाएगा. चलो फ्रेंड्स, अब इसे मॉड्यूल में से देखते हैं. लेट अस सी इट फ्रॉम मॉड्यूल. एनी पर्सन अग्रीड बाय, दिस वुड बी ए कैटेगरी. एनी पर्सन अग्रीड बाय द ऑर्डर ऑफ सेट मे फाइल एन अपील टू सुप्रीम कोर्ट. द अपील कैन बी फाइल्ड ओनली ऑन क्वेश्चन ऑफ लॉ. मैंने बताया ना, फैक्ट फुल एंड फाइनल. द अपील शुड बी फाइल्ड within 60 days from the date of communication of order of set and for sufficient reasons, right, Supreme Court may condone the delay. Right, so this is the point of condonation of delay by Supreme Court. Same, set भी condone delay करता था, ये भी करते हैं. खाली फर्क क्या था, सेट के ऑर्डर सेट में जाना तो 45 डेज था, यहाँ पे इट इज 60 डेज, नथिंग मोर.
The next provision after we had a sound revision with respect to appeal to set. Friends, again I told you that we went for revision so that you get a complete understanding, because that provisions are common with all other provisions. Now friends, the next is, a foreign tourist came to India and he purchases some antiques from a shop. He would like to pay US $30 in cash to the shopkeeper. Comment in light of FEMA whether shopkeeper is permitted to accept foreign currency. Then the answer is no. Indian shopkeeper cannot accept foreign currency, but if Indian shopkeeper is registered as an authorized dealer, then the scenario would be different. But normally, the answer is no. So, if we try to understand that, as per section 3 of FEMA, save as otherwise provided in this act, rules or regulations made thereunder, or with the general or special permission of RBI, now very important, no person shall receive any payment by order or on behalf of any person resident outside India in any manner. मीन्स इंडिया के किसी इंसान को किसी बाहर वाले इंसान के बिहाफ पे पेमेंट नहीं लेना चाहिए, अदरवाइज थ्रू एन ऑथोराइज्ड पर्सन. इफ यू आर डूइंग थ्रू ऑथोराइज्ड पर्सन, देन इट्स फाइन. When any person in or resident in India receives any payment by order or on behalf of any person resident outside India, means here there is PRI, here there is PRY, through any other person without a corresponding inward remittance from a place outside India, then such person shall be deemed to have received such payment otherwise through an authorized person. Means if I am PRI, I am receiving a payment from PRY. If PRY sends to an authorized person, an authorized person gives to me, then it's fine. But without the inward remittance, if directly authorized person gives to me, though I have received from authorized person, it will be treated as if I have not received from authorized person. So first the inward remittance should come and then only authorized person should give it to me. Here in the given case, the foreign tourist wanted to pay foreign currency in cash on purchase of antiques to shopkeeper. So foreign tourist is PRY, shopkeeper is PRI, which as per section 3 is not permissible to any person to receive any payment by order or on behalf of any person resident outside India in any manner except received through an authorized person. And therefore, now important, shopkeeper cannot accept cash as it will be received otherwise than through authorized person, except where the shopkeeper has taken a money changer's license to accept foreign currency. And if you become a money changer, then you become an authorized dealer, and then it's a different thing. Then you can always go for the same. This is one thing. Next, comment upon the nature of offence committed under PMLA. In case a spouse sold their property in 175 lakh to Mr. Y, in lieu of the sale, they obtained rupees 100 lakh through RTGS in his account and rest 75 lakh in cash, which he transferred to its wife's offshore, that is foreign bank account. Examine the liability of the spouse in the given case of PMLA. Also state whether he can be, they will be released on bail or not. The offence is cognizable offence. Because it's of money laundering, criminal in nature. Offence under the act shall be cognizable and non-bailable. Means once if the person is arrested, right, then it will be non-bailable. Yeah. If the person wants to be released on bail, some strict procedure needs to be followed. Person accused, punished of an offence under this act shall not be released on bail or on his own board unless the matter will go to special court and there will be a case in special court, and the lawyer of the offender will say that the person should be released on bail, and on opposite of that there will be a public prosecutor who will say that bail should not be given. In that, it is proved what? Let's see. The public prosecutor has been given an opportunity to oppose the application for such release, and when the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that the person is not guilty of such offense and that he is not likely to commit any offense when he is on bail. Then in that situation only the person can be released on bail. So Mr. Spouse जिसने गलती की है उसके लिए तो बहुत difficult हो जाएगा. But if we talk with respect to the wife, then for her it will be very easy. If a person who is under the age of 16 years, or in case is a woman, or sick or infirm, or is accused either on his own or along with the co-accused of money laundering, a sum of less than 1 crore rupees, here it was less than 1 crore rupees, may be released on bail if the special court so orders. So important is this. As a said section, the spouse are liable for commission of offence of money laundering by transferring an unaccounted money obtained through sale of their property to an offshore bank account of his wife with an intent to evade tax. So there is money laundering. As the husband and his wife, their spouse jointly acted in commission of act less than 1 crore rupees because it is 75 lakh. So the wife may be released on bail if the special court so directs, whereas the husband shall be released on bail or on his own bond only on compliance of the above stated provision. So first, the appeal shall be made to court. The opportunity of being heard shall be given. The public prosecutor will oppose the application, and in that it is proved that the spouse is not responsible, or till the case is final, if the spouse is released on bail, during that bail, the spouse will not commit any offense. If all these conditions are seen to it, then and only then you can say the person can be released on bail, else the person cannot be released on bail. So this was another important provision with respect to releasing the person on bail. So now the third last question for RTP. X is an association having a registration to transfer the foreign contribution received by it to another organization. Is it valid act of X? If yes, then what is the process to do so? Is there any restriction on transfer of funds to other organizations? So basically this is with respect to Foreign Contribution Regulation Act. Now friends, bear in mind, a registered recipient this is also registered recipient Can the unregistered recipient receive foreign contribution? No. Then dotted line is with respect to Can a registered recipient transfer to another registered recipient? Yes. Can a registered recipient transfer to an unregistered recipient? But when a registered recipient is transferring to unregistered recipient, to see to it that only maximum 10% of the receipts can be transferred. Moreover, the registered recipient has to ensure and to declare the same in its own annual return, and also the unregistered recipient has to declare in his own annual return, and they need to ensure that it is being used for the purpose for which it was being received. Then and only then they can transfer the same. So yes, X can transfer the foreign contribution received by it to another organization. According to the provision, no person who is registered and granted a certificate or has obtained prior permission of act and receives any foreign contribution shall transfer foreign contribution to any other person unless such other person is also registered and has been granted a certificate. Means one registered person and another registered person, that transfer is always allowed. Provided that such person may transfer with the prior approval of central government a part of such foreign contribution to another person who has not been granted a registration. So a registered person can transfer a part of its contribution to unregistered person subject to prior approval of government. Means in that the government's approval is needed. And you cannot transfer the full, you can transfer the part. Let's see the rules. A person who has been granted a certificate of registration or prior permission means a registered person. And intends to transfer part of the foreign contribution received by him to a person who has not been granted a certificate or prior permission may transfer such foreign contribution to the extent not exceeding 10% of total value thereof, and for this purpose make an application to central government. Central government means CG, Ministry of Home Affairs. Every application made shall be accompanied with a declaration to the effect that the amount proposed to be transferred during the financial year is less than 10% of the total value of foreign contribution received by him during the financial year. And the transferor, that is Mr. X, shall not transfer any foreign contribution unless central government approves the transfer. यानी जब तक गवर्नमेंट अप्रूव नहीं करेगा तब तक हम ट्रांसफर करेंगे. A person who has been granted a certificate or prior permission shall not be required to seek the prior approval of central government for transferring the foreign contribution received by him to another person who has been granted a certificate or prior permission. Means registered, no approval is needed. Registered, unregistered, approval is needed. Provided that the recipient has not been proceeded against under any provisions of this act. यानी जो recipient है उसके ऊपर कानूनी कार्यवाही चलनी चाहिए. Both transferor यानी Mr. X and the recipient shall be responsible for ensuring proper utilization of foreign contribution so transferred, and such transfer of foreign contribution shall be reflected in the returns in form to be submitted by both transferor and the recipient. So दोनों लोग जब अपना एनुअल रिटर्न भरेंगे एफसीआरए के अंदर, एफसी फॉर्म FC4 में, तो दोनों अपने अपने एनुअल रिटर्न में बताएंगे कि भाई उन्होंने कैसे पैसे रिसीव किए, कहां से पैसे रिसीव किए और कहां उन्होंने इन पैसों का उपयोग किया. सो रजिस्टर्ड के बीच में ट्रांसफर के ऊपर उतने रेस्ट्रिक्शंस नहीं है, पर रजिस्टर्ड अनरजिस्टर्ड के अंदर देयर आर वेरियस रेस्ट्रिक्शंस. The second last question. Anil, who is a chartered accountant with his own independent practice, is an arbitrator in an arbitration between Tata Tea and Suzuki Limited. Scenario 1. Prior to starting his practice, Anil had worked for 5 years with Tata. So in my view, he should not be appointed because some partiality may be there. Second scenario. During the proceedings before arbitral tribunal, Anil would allow Tata Tea to take many liberties. For instance, taking as much time for making oral arguments, cross-examination with witness for submitting documents, etc. Also, the proceedings were adjourned wherever so requested by Tata. When Suzuki Motor wanted to take extra time, they were not allowed. In few instances where they were permitted, they were asked to pay a heavy cost to Tata for delaying the proceedings. Suzuki Limited, on basis of above scenario, wanted to challenge the appointment of Mr. Anil. State whether the appointment of Mr. Anil as an arbitrator can be challenged. So, obviously it can be challenged. Let us see the answer. Very simple, direct question it is. When a person approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, such as either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or any kind, which is likely to give rise to justifiable doubts as to his independence or impartiality, and which are likely to affect his ability to devote sufficient time to arbitration, and in particular his ability to compete with entire arbitration within a period of 12 months. So one is with respect to independence or impartiality, and one that he will be able to complete within 12 months, and if there is any right. In the first case, Anil has worked for 5 years with Tata Inc. In this situation, a law would deem Anil of lacking independence, because there is a list available, like if you have been a partner or a lawyer or a counselor or an employee, you are lacking in independence. In the second case, arbitrator by his or her behavior gives an impression that he is favoring one party over the other, and so the arbitrator may be challenged only if circumstances exist that would give rise to justifiable doubts as to his independence or impartiality. In given scenario, it would be deemed that Anil to be lacking independence, and whereas in second case, it clearly reflects that the arbitral tribunal, that is Anil, favors and is partial towards Tata T, and therefore lacks impartiality. So yes, appointment of Mr. Anil as an arbitrator can 100% be challenged. Last, X company is a holding of Y company. Insolvency resolution process was initiated against X on 15 December 2020. In the meantime, another financial creditor initiated insolvency of Y. Later on, X filed an appeal contending the resolution process against Y should not continue till the insolvency process is decided on in case of X, on basis of initiation of moratorium. Also, the resolution plan of X approved by Committee of Creditors was still pending before adjudicating authority, that is NCLT, for its approval. In the light of given situation, examine whether corporate insolvency resolution process started against X can stop or can bar the corporate insolvency resolution process initiated against Y Limited. So this will be a last case based on insolvency and bankruptcy code. In the given case, both X and Y in the eyes of law are separate entities. Further, section 14, which deals with moratorium, nowhere prohibits initiation of corporate insolvency resolution process on the subsidiary company or its holding company. It has no connection. Further, also separate CIRP has been initiated against another corporate debtor by another financial creditor, which is altogether separate and have no connection with the corporate insolvency resolution process started against Mr. X or Mr. Y. Therefore, in the given case, corporate insolvency resolution process initiated against X, which is a holding company, cannot stop the corporate insolvency resolution process initiated against Y, which is a subsidiary or vice versa. So it has nothing to do with respect to that. So friends, hereby we end up with the discussion of the RTP, which is applicable for May 2021. And again, I'm clarifying that normally when the RTP is there, it includes both amendments and you can say the questions. This time RTP is having just questions because the latest module is an amendment one. Now before we end up, would like to convey a best of luck to all the students who are pursuing for May 2021. Also an important note for all the students who are pursuing for November 21 and onwards, that in case you are watching this RTP, then certain answers may change because various amendments were introduced by way of budget. And lastly, on behalf of Navkar Digital Institute, would like to pay a sincere gratitude to ACCA, the Board of Studies, and all the faculty members who directly or indirectly contributed in making this particular RTP and for publishing this for the betterment and knowledge upgradation of students at large. Thank you. See you soon in any other video of Navkar Digital Institute. Thank you.
If you like this video, share it with your friends. Subscribe to our YouTube channel to watch more such videos and learn from our expert faculty members. Press the bell icon to get regular notifications whenever we upload a new video. Download NDI mobile app to get complete CA course online. We value your support. Thank you for watching.